Hello and welcome to this episode of the Diary of a Lawyer. And today I just want to just provide a synopsis of one of the increasingly interesting or bizarre directions in some of the specific court cases coming from the United States. And this specific one is in relation to the Southwest Airlines, which a Trump-appointed judge has surprised and shocked and in some respects saddened the respectability and reputation in some respect of the US judiciary. And essentially what some people have described is as quote-unquote another day and another extremist ruling by what they call yet another apparent extreme Trump-appointed judge. And the decision is from Texas. And according to observers, they describe it as straight out of the Handmaid's Tale, quote-unquote. So the judge held that lawyers for Southwest Airlines were in contempt of court for their actions in a religious discrimination case brought by a former flight attendant and ordered them to undergo quote-unquote religious liberty training. And not just any instruction, but training conducted by the Alliance Defending Freedom, ADF, brackets in short, which is described as a conservative group that litigates against same-sex marriage, transgender rights, and abortion rights. So the issue arises from a lawsuit filed by Charlene Carter, who was a flight attendant for more than 20 years and a longtime antagonist of the Southwest Flight Attendants Union, as described. And in 2017, after union members attended the Women's March under quote-unquote Southwest Airlines flight attendants banner, Carter is said, according to the lawsuit, is alleged to have sent Facebook messages to the union president containing graphic anti-abortion messages. And in direct quotation of what the message says, it says, quote-unquote, "This is what you supported during your paid leave with others at the Women's March in DC, March being in Capitol. You truly are despicable in so many ways," Carter wrote in one message accompanying a video of an aborted fetus. After the union president complained, Southwest fired Carter, saying her conduct crossed the boundaries of acceptable behavior and was inappropriate, harassing, and offensive, quote-unquote, and did not adhere to Southwest policies and guidelines. An arbitrator found that Southwest had just cause for the firing. Carter, then represented by the National Right to Work Committee, sued, claiming Southwest and the union violated her rights under federal labor laws and Title VII. The federal job bias law bars employers from discriminating on the basis of religion, and Carter claimed she was dismissed because of her sincerely held religious beliefs against abortion. A jury found in her favor, overwhelmingly so, and it awarded her $5.1 million through U.S. District Judge Brantley Starr, although the U.S. District Judge Brantley Starr reduced the amount to about $800,000, and the case is being appealed. The part that has caught the attention of just general observers and the public is that the judge, Starr, instructed the airline to, quote, inform Southwest flight attendants that under Title VII, Southwest may not discriminate against Southwest flight attendants for their religious practices and beliefs, That still sounds generally reasonable. Instead, that Southwest said in a message to staff that court ordered us to inform you that Southwest does not discriminate against our employees for their religious practices and beliefs, quote unquote. So what then followed was that the judge was not happy and was described as ticked off by what he viewed as insubordination, and in an opinion released this week, held Southwest in civil contempt of court. And he's quoted as saying that in the universe we live in, the one where words mean something, Southwest noticed it didn't come close to complying with the court's order, the judge said. He went on to be quoted as saying that to make matters worse, Southwest had circulated a memo about the decision to its employees, repeating its view that Carter's conduct was unacceptable and emphasizing the need for civility. He's quoted on going to say that Southwest's speech and actions towards employees demonstrate a chronic failure to understand the role of federal protections for religious freedom, Star decreed. He then proceeded to order 3 Southwest lawyers to undergo 8 hours of religious liberty training, a move he described as, quote unquote, the least restrictive means of achieving compliance with the court's order, which is a clause in the Constitution. Luckily, it was observed, the judge went on to observe that there are esteemed non-profit organizations that are dedicated to preserving free speech and religious freedom, quote unquote. The judge added a footnote citing that ADF's litigation of Masterpiece Cake Shop v. Colorado Civil Rights Commission in the 2018 Supreme Court case, which involved the baker who refused to make a custom wedding cake for a same-sex couple. He is quoted as saying that some of those entities laudably provide training free of charge for those who have struggled to respect religious liberties in the manner federal law requires, the judge said, terming or classifying or describing ADFs as particularly well suited to train Southwest employees who are most responsible for the communications at issue here. Now, this, according to observers, is described as not even close to normal. And they claim that Southwest trampled on Carter's religious. They provide an analogy, an assumption that says even if it was assumed that Southwest trampled on Carter's religious rights, although they argue that it seems highly dubious because there is scant evidence that the airline was motivated by animus towards Carter's Christian faith. And even if they generously also assume that Southwest flagrantly defied the judge's order, again, although according to observers, the airline did offer to send out a revised notice to employees. And another assumption, according to observers, is that let's assume that this behavior justified the extraordinary step of holding the company to contempt. And they're going to surmise that even if all those issues were assumed, the notion of subjecting lawyers to a re-education campaign by the likes of the ADF is described as tantamount to creating a government-endorsed thought police, quote unquote, not my words. And they go on to observe that the uproar that would be comparable if other left-leaning or liberal-leaning federal judges order the same instruction, such as to take re-education, say, by Planned Parenthood, which is a non-profit or an organization that deals with abortion. They observe that the response will be very, very strong. And understandably, human rights groups or civil rights groups, as it's generally known in the US, like the Southern Poverty Law Center, have labeled the ADF a quote-unquote hate group. And although that may be perceived as going a bit too far, the group is described as not being a neutral arbiter of constitutional values, and it's simply described as an advocacy organization that apparently takes zealous, extreme, offensive position. For example, they cite that it has allowed quote unquote practicing homosexuals to serve in the military, or it has argued that allowing quote unquote practicing homosexuals to serve in the military or adopt children constitutes what they group terms as quote unquote attacks on family values that will ultimately destroy society, their words. And in a friend of the court brief in Lawrence v. Texas, the case in which the Supreme Court struck down laws criminalizing homosexual conduct, the organization argued that they should be upheld because quote-unquote same-sex sodomy is a distinct public health problem. Their words again, and I'm quoting them verbatim as words attributed to them by observers. There's also reference to the organization's former president who co-wrote a book which is titled quote-unquote the homosexual agenda, exposing the principal threat to religious freedom today, again quote unquote, in which he is alleged to describe or do link certain practices to certain practices that, let's just say, are not complementary to people of that persuasion. There's reference to some descriptions on its website describing, stating that redefining marriage is ultimately part of a larger effort to redesign society in order to give social approval of certain behavior and to empower social acceptance of alleged, what it describes as forgery of gender and sexual practice at odds with natural law and the faith of millions, quote unquote. And they claim that these are not just random examples, but apparently allegedly embody the organization's core convictions or beliefs to which members are fully entitled under the First Amendment, an observation which they have the right to promote. But I think what is described as a far cry is the judge description or the alleged reference to the group as quote unquote an esteemed group, which is particularly well suited to train Southwest employees and order the lawyers to a form of re-education to be done by the organization. And so there it is, in a nutshell, an employee is fired for what is clearly appears to be, by all intents and purposes, inappropriate comments against other employees. She then sues the organization, Southwest Airline, under the religious freedom or constitutional protected right. The judge makes a ruling. An award is reduced from the earlier award and orders the organization to provide a certain level of information to its employees, which, in his view, was not sufficient to his standard, but then orders then the lawyers to attend re-education by an organization. Okay. Okay. By an organization that is that is described in terms as not particularly suitable for retraining any lawyers in terms of religious issues and First Amendment. And so there we shall leave it on this episode of the Diary of a Lawyer. Thank you, and we'll speak again. Thank you. Bye.